He graduated cum laude with a degree in English Studies, majoring in creative writing, also from the University of the Philippines. He was president of the Law Student Government in the University of the Philippines, currently the managing partner of Javier, Santiago, Torres, and Panghulan Law Offices. Let us all welcome Attorney Joshua Santiago.
Good afternoon mga ka-OSHmates, mga OSHmates and ka-TGFI. It's an honor to speak before you on the basics of estate planning. Again, I'm Attorney Joshua Santiago, and it is my joy to share with you what I know about estate planning. So let's get started. Sabi po sa Proverbs, chapter 13, a good man leaves an inheritance to his children's children, but the sinner's wealth is laid up for the righteous. So kung tayo ay maayos at mabuting tao, mag-iiwan tayo para sa ating mga anak at pati sa mga apo natin. What exactly is estate planning? Para po yan, sabi dun sa isang case, the estate of a dead person could be considered as an artificial juridical person for the purpose of settlement and distribution of his properties. Parang mahirap lunukin, Basically, ganito po yun. Pag namatay ako, lahat ng ari-arian ko pupunta sa bag. Yung bag na yun yung estate ko. May pangalan siya, may personality siya for purposes of settling my estate, magbayad ng taxes, magbayad ng utang, at sa huli, kung ano matira, yun ang ibibigay niya sa mga naiwan ko na mahal sa buhay. O kung kanino ko man ipapamigay kung meron akong last will and testament. What is estate planning? Estate planning ay, yun nga, yung pag namatay tayo, yung iiwan natin yung bag, di ba? Yung estate, yung kabuuan ng ating ari-arian. It's a process of preparing for the inevitable so that yung mga heirs natin o yung mga tagapagmana natin will not be additionally burdened in the event of your or my passing. So this is also the process by which one can designate beneficiaries who may or may not be compulsory heirs. So pwedeng hindi mo anak o asawa o magulang, pero gusto mo bigyan. Halimbawa, gusto mo ibigay yung aso mo o yung libro mo na alam mong gustong-gusto niya, such as to a friend, an organization, the church, or even the state. Pwede mo i-donate yung lupa mo para sa tayuan ng museum o gawing park. Pwede yun. Pwede natin gawin yun through estate planning. It can be, dalawang klase siya, judicial or extrajudicial. Yung judicial, ito yung dadaan sa court, papaprobate yung will, or kung halimbawa, in the sad event na hindi magkasundo-sundo yung heirs for the settlement of the estate. Halimbawa, hindi sila maka-execute ng extrajudicial, pipirma na lang sila, mag-agree na lang sila paano hahati-hatiin yung estate natin, pupunta sila sa court, sasabihin nila, Judge, ito yung namatay, ito lahat ng ari-arian niya, hindi kami magkasundo, kayo na ang mag-decide. Itong sa palagay ko, itong sa palagay niya. Or again, the best way is of course extrajudicial para bawas na rin sa gastos at tipid sa oras para makamove on na tayo lahat, diba? Kasi but some cases talagang walang choice dahil minsan may deception or merong nadedehado. In those cases, then we can go the way of the judicial route. But of course, if we can talk it out as much as possible, pag-usapan na lang po. Now, how do you settle estates? Dalawa ulit, di ba? Sinabi natin intestate tsaka testate succession. Yung intestate succession, ito yung walang last will and testament. So, pwede extrajudicial settlement na lang ang mangyayari. Dahil ano naman yun given naman yung hatian by law, by operation of law. Unless may mga special circumstances o special na bilin, yun. Sana pag-usapan na lang ng mga heredero o tagapagmana. But if the heirs disagree, kung walang last will and testament, pwede naman, nasabi ko kanina, to file a petition for partition, parti-partihin or settlement of estate before the courts. Yung second way naman is yung testamentary succession. So if there is a will at nag-agree naman yung mga heirs, pwede na lang nila sabihin na extrajudicially, ito yung wishes nung namatay. Pwede po yun para mas tipid din. Pwede rin kung tayo yung susulat ng will, if it's okay with me na gumawa kayo ng extrajudicial settlement reflecting yung terms nitong last will and testament ko, and you don't need to go to court. Kasi pag may last will and testament, kailangan pumunta sa court. Ngayon, pag extrajudicial settlement, sasabihin mo under oath na walang will, di ba? Pero kung pumayag naman yung nag-iwan ng will, na as long as nagkakasundo kayo, ito masusunod, ayon sa kagustuhan ko, sabihin nyo na walang will, okay lang sa akin yun. So, and then the second kind is testamentary succession. There's a will and the heirs are in agreement. Pwede naman tayo mag-agree and have it done extrajudicially, yung banggit ko nga, or kung hindi talaga magkasundo, again, sa court, papaprobate yung will. Kasi minsan, peke yung will, o may ginawang kasunod na will, yung pinakita yung lumang will, nung pabor pa kay kuya, ngayon pabor na kay ate. So, nagtatalo ngayon yung dalawang will. Doon, kailangan natin ng probate at settlement of the estate in court. The judge will decide based on the evidence, ano ba ang karapat-dapat. Of course, as a rule of thumb, the later will supersedes the earlier will. Kasi syempre, karapatan ng tao habang buhay siya na magbago yung isip niya. We'll talk more on that later. So what are the basics of succession? Dun sa yung rules ng succession, parang sa family computer dati, para sa unlimited life sa kontra, mga old enough who grew up in the 80s, down, down, up, up, left, right, BA, then start, di ba? So yung down, down, mauna yung descendants, pababa muna. And then up, up, parents or grandparents, ascendants. And then left, right, kung walang ascendants or descendants, saka palang papasok yung collateral relatives up to the 5th degree. Ano yung 5th degree? Per degree, aakyat ka dun sa common descendant. So halimbawa, kapatid ko, 2nd degree siya kasi aakyat ng isa sa parents ko, then 2nd, bababa sa kanya. Kung pamangkin ko lang natira, 3rd degree siya kasi akyat 1, 2 sa kapatid ko, down sa anak niya 3. So gano'n, up to the 5th degree. And then BA, basta asawa meron. Palagi pong may share ang asawa. Aside from the conjugal share, she also, yung kalahati ng assets na may iwan natin, the spouse also has a share in the inheritance alongside the other forced heirs. So, halimbawa, dalawang anak, yung property say 6 million. So, yung 3 million doon, conjugal ni Mrs. Tapos yung 3 million, tagi 1 million sila ng dalawang bata. And then the descendants, exclude the ascendants. Kung may descendant, wala na yung ascendant, wala na rin yung collateral. And under the laws of succession, the illegitimate children get half the share of the legitimate. Tapos kung walang available collateral relative, kung walang available na ascendant, descendant, or asawa, yun. Then everything goes to the collateral relatives up to the 5th degree. Yan yung mga sa TV na bigla lang may namatay na uncle o auntie o grand aunt na single, tapos ikaw ang biglang heredero na dami mong minanabigla. So, yun. What can you give away by testamentary disposition? Anong pwede natin isama sa ating last will and testament? Actually, kung wala tayong forced heirs, ibig sabihin wala tayong asawa, ascendant, or descendant, yun yung qualification up to half of your estate. Ngayon, kung wala na talaga, ba, single, never nag-asawa, never nagkaanak, pwede pamigay lahat. So, yun yung qualification. And then there are 2 kinds of wills. Pwedeng holographic, which is yung handwritten lang, sinulat kamay lang, dapat lahat sulat kamay. All the dispositions have to be in the penmanship of the person. At dapat, i-compare ito sa other documents reflecting their penmanship. So kung meron siyang journal, meron siyang listahan ng pautang, meron siyang mga letters to loved ones or relatives, yun ang basis ng comparison ng holographic will. And then secondly is the notarial will. It has to be subscribed and sworn before a notary and 3 other disinterested witnesses. Yung 3 witness na yun, hindi pwedeng may mamanahin. Kaya sila disinterested. So wag na wag kayong gagawa ng will na isa sa mga testigo ay tagapagmana ninyo, kundi susumpain kayo later on dahil that will be an invalid will. So what are the steps in estate planning? Diba? Ito na tayo. Kanina, yung rules, di ba? The first step is collation. Una, tipunin nyo muna. Ano ba yung meron? Baka naman wala. Huwag na tayo mag-estate planning, di ba? May utang pa tayo. Step 1 is always collation. Ano na yung mga assets natin? Which comprise of lands. Ito. Basis nito, titles, tax decks, deed of absolute sale. Kung halimbawa walang titulo, bumili kayo ng condo, at yun yung proof na meron kayong ownership. Bank deposits, cash. So, kailangan nito publication. Kailangan nito ng publication, and then there will be a 6% withholding by the bank kung ilalabas. The heirs have to present the TIN of the estate bago sila maka-withdraw, and a sworn statement of the heirs na buhay pa sila as co-depositors and subject to final 6% tax. And then, kung kukunin yung pera sa bank, mag-i-issue naman yung bank na BIR Form 2306. Ibig sabihin, sila na yung nag-withhold ng 6% na estate tax para sa gobyerno. Para hindi nyo na isasali yun later on kapag ka nag-compute kayo ng, o kapag ka sinettle nyo yung estate, i-attach nyo na lang yun para hindi nyo nababayaran yung portion na yun kasi bayad na. Nag-withhold na si bank. So, yun. Rules on and/or accounts. Iba ginagawa ngayon, and/or. So, under the BSP ruling, ang ano po dyan is kapag meron akong co-depositor, then the co-depositor is deemed to own half. So, ang pwede lang i-freeze kapag halimbawa nalaman ng bangko na matay na ako, yung kalahati ko lang. Yung kalahati ng co-depositor ko, halimbawa yung anak ko o yung asawa ko, hindi nila pwede i-freeze up to that half. Ano pa po ang mga assets natin? Stocks, publicly listed. So we have to get PSC certification, yung stock exchange or newspaper closest to the date of death, kung ano yung value ng stock na yun. Usually kinukuha nila yung high and low tapos i-average. So kung mababa ang presyo ng stock nyo nung oras na yun na namatay kayo, di medyo blessing in disguise yun. Although hindi pa rin masyadong good news kasi nga namatay ka. But the good news is medyo mababa yung taxes no. And then who knows, the day after or by the time na matransfer yung stocks, nag-improve na siya, nag-appreciate na siya significantly. Katulad ngayon, maraming namamatay, masama rin yung stock market, so that could be valuable later on. And at the same time, the valuation of those publicly listed shares of stock are quite low during this time kasi nga bagsak ang stock market. Kung private unlisted companies naman, marami nang nagsara na ganon. Meron kami mga settle na estate. Usually yung mga sugar mills, yung mga old companies na wala na po ngayon or hindi na masyado active. You just get their audited financial statements as of the last fiscal year prior to your death. So kung namatay ng 2021, ang fiscal year nila ends the calendar year of 2020, kukunin lang po natin yung financial statements nila. And then kung magkano yung value ng share of stock, yun na yung yung Victoria's Milling, yung mga ganon. Azucarera, usually yung mga ganong mga private unlisted companies. What else? Insurance proceeds. So ito, very interesting ito, di ba? Kasi sinasabi ng mga insurance companies, mga kaibigan natin sa financial planners, they are a good buffer for payment of estate taxes. Tama naman. But they are taxable if they are revocable. Kung irrevocable, hindi po siya taxable. So, halimbawa, I name my wife as my irrevocable beneficiary or my children, irrevocable, okay, we're safe. But if revocable, nakalagay, kasi nga naman, advice rin ng iba, gusto mo, may pros and cons eh. What if nakuhain ka ng asawa mo, di ba? Mabuti, gawin mo ng revocable para just in case. Pwede mong bawiin. Kasi pag irrevocable, niloko ka na, finance mo pa siya. But the exception is if it's revocable, pero the beneficiary has not been changed or has never been changed, it can be exempt from the taxes. So this is the exception to the exception. Okay, so sabi dito, when the except when it is expressly stipulated that the designation is irrevocable. So taxable siya, di ba? This is section 85 of the Internal Revenue Code. And like I said, the exception to the exception, sabi naman sa insurance code, in the event the insured does not change the beneficiary during his lifetime, the designation shall be deemed irrevocable. So pag hindi nga binago, irrevocable na siya, then hindi na siya taxable. Another type of asset is yung club shares. Uso po dito, pwedeng celebrity sports club, mga sports clubs, Makati Sports Club, or pwede rin golf club shares sa Riviera, mga Santa Elena, mga elite na club shares, ano? Can be rin mga vacation shares. Kasama po siya. And then after you collate everything, you distribute it ngayon. Ano ba ang distribution nito? Pag intestate succession, medyo madali. Lalo na kung may descendants, ascendants, spouse. So it just happens by operation of law. And wala po tayong choice doon. We can probably agree as to the, halimbawa, tatlo yung property, alin yung ayo, alin yung akin. But sometimes, pagka hindi pantay-pantay yung makukuha na value, merong additional donors taxes on the part of the person na dehado, kasi siya na nga yung dehado, no? Siya pa yung na donors tax. But of course, this can be taken out and charged to the estate. Again, these are the rules. Down first, descendants, then ascendants, and then collateral relatives pa lang up to the 5th degree. But basta asawa meron. Meron always. Spouse always shares. And again, the descendants, pag may anak, may apo, exempted na yung magulang. Illegitimate children get half, and if no descendants or spouse available, like I mentioned earlier, collateral relatives up to the 5th degree can inherit. So ano ba yung 5th degree? Halimbawa, siguro, meron akong lolo. So 1, parents ko, then lolo ko, then meron akong uncle, 3, meron siyang anak, 4, meron siyang anak. So parang up to my grandniece, hindi lang pinsan, kundi up to my hindi lang pamangkin, kundi pati sa grand, tama ba? Umakyat 1, 2 sa lolo, 3, 4 sa anak ng kapatid ng parents ko, and then 5 sa anak niya. Yun. So up to the 5th degree can inherit. Ano naman sa testamentary succession? 50%, the rules on intestate succession apply. Again, if merong ascendant, may anak, apo, or may magulang, lolo, o may asawa, kalahati lang ang pwede natin ipamigay by testamentary disposition. The rest will be tempered by law. So, halimbawa, sumobra sa 50% yung pinamigay mo, hindi po pwede. Kailangan mauna yung ating mga forced heirs. At hindi sila dapat ma-deprive ng legitimate nila ng karapat-dapat. Unless you have disinherited them for valid grounds. Like, nagtaksil sila sa'yo, nag-attempt on your life. So, yung mga yun pwede. Or, in terms of legal separation, alam mo, maganda dito yung legal separation. Hindi kukunti lang nakakaalam nito. But sometimes we advise clients na halimbawa nagloloko yung asawa nila. Bakit mo bibigyan ng annulment? Di nakasama niya na yung adulterous relationship niya. Yung babae niya, di ba? Nabigyan siya ng laya, tapos hati pa kayo sa assets. Minsan, pag yung lalaki, siya pa yung may mga assets na natatago sa misis. So sometimes we advise you file legal separation. That way, if he is the guilty spouse, you can inherit from him, but he cannot inherit from you. Diretso sa anak nyo. And then, yun, syempre, hindi siya makakapag-asawa ulit. Wala siyang freedom, di ba? To do what he wants. He will not be rewarded for what he did. But of course, kanya-kanya rin po yan. Sometimes also, we want to be free from an abusive relationship. And in such cases, pwede rin naman annulment na lang. 50% can be disposed of by will. So yung 50%, assuming merong tayong asawa, anak, o forced heirs, we can give the half away. We can give, kung yung lupa natin ay meron ng 50% yung ating mga mahal sa buhay, and the 50% meron pa tayong gustong ibigay as a museum, as a park, as a playground. Ayun, we can do that. We can dispose of that by will. So again, the two kinds, notarial will, ito yung before a notary public, plus 3 witnesses. So 4 na tao ang dapat na naroroon sa pag-execute nitong will na to. Pipirmahan mo, pipirmahan ng lahat ng testigo sa lahat ng pahina, and of course yung notary public will finally stamp and notarize the document. And again, you have to remember na dapat wala dun sa mga witnesses ay tagapagmana. Otherwise, the will can be challenged. And then yung holographic will, yung sulat kamay nga. But you know what? Ngayon, since we have modern technology, we advise clients, kung gagawa kayo ng last will and testament, you record yourself. Madali lang naman, lagay mo yung phone, patong, or yung laptop like this via Zoom, and you say that this is my last will and testament. Tapos pakita mo sa camera, and you say, I'm doing this of my own free will, I am of sound mind, sound discretion, I'm in perfect health, nobody forced me to do anything to write this or to give this away in any manner that is contrary sa kagustuhan ko. So yun, maganda yun. That's an extra insurance. And of course, what we also advise, kung talagang gusto natin na yung will natin masunod, ay i-probate na yung will habang buhay pa tayo. Yes, pwede po yun. Habang buhay pa, pumunta ka sa court, sabihin mo, Judge, this is my last will and testament. Ito yung gusto kong mangyari kapag in the event of my passing. And of course, the court will say, oh sige, okay yan. Diba? So, nandun na, it's a public record na. So, you need to probate it. Then thirdly is the transfer. You have to pay taxes. Computation, ngayon maganda na. Standard deduction, 5 million. Family home, 10 million. Yan lang yung conjugal share mo. So, about the house is worth 20 million. Mag-asawa may-ari. So, tag 10 million sila ang family home exemption. Provided they can prove that resident talaga sila doon, may exempt yung family home from taxes. Yun yung maganda sa train law. And the rate ngayon is 6% na, flat, in excess of this. Unlike dati, umaabot ng 20%. So but if you're a non-resident Filipino or foreigner and your estate is settled here, 500,000 po ang standard deduction. So medyo maliit lang. And then the rest subject to 6%, which is mababang rate pa rin. So ano mga challenges? So sometimes may bago tayong partner, though still married to the former partner. So this happened. Merong recent case where somebody left something to his live-in partner, his common law wife. But unfortunately, turns out the common law wife hindi pa pala annulled. So meron mga void donations. So these are not allowed under the law. And so the insurance company, even though she was named in the last will, was denied her claim for the benefits. Sometimes ito, yung di maiwasan, second families or bigamous marriages. So unless ma-annul yung marriage or ma-declare bigamous, yung mga anak dun deemed legitimate. So paano ngayon hahati-hatiin ito? No? And then multiple wills. Paano kung maraming will na iniwan ang yung mga pabago-bago ng isip, no? Or maraming heirs kasi mayaman si uncle o si lolo. Falsified wills, yun, annulment versus legal separation. We touched on that earlier. So some do's and don'ts, just a few tips. Tatlo po, do let someone know about it. Paalam niyo sa abogado, paalam niyo sa trusted friend, paalam niyo to somebody na hindi naman sakitin at mas matanda sa atin. There's a good chance na mauna pa sila sa atin. Huwag ganun. Kasi otherwise, paano nila execute yung last will natin, di ba? Keep your files and copies in a safe place. Gumawa tayo ng multiple copies. And we inform our loved ones na nakalagay ito. And feel free to update your will from time to time. Circumstances may change, di ba? Baka lumit yung assets natin, baka madagdagan, dadagdagan tayo ng apo, ng anak, hindi natin masabi. So you feel free to update your will from time to time. Ang mga don'ts, don't make a joint will. It is absolutely void under the law. Don't give to unknown persons na may dadaan dito ng alas 12 ng gabi, naka-blue, ganyan, sa ganitong oras, sa ganitong petsa, ibigay lahat sa kanya. Hindi void yun. At hindi mo rin pwede pagbawalan na inalienable for more than 20 years. So usually sa mga apo, di ba? O sige, ito sa apo ko, provided hindi ibebenta hanggang sa lumaki siya. Pwede up to 20 years. Kasi nga baka mawaldas habang siya ay bata pa. But we cannot keep the property forever. And then yun, don't give to a witness to your will. Nabanggit na natin yan kanina. So ito po yung aming contact information. In case you have questions or you wish to seek further legal advice, we are available through the contact numbers on your screen. Okay, so dito po tayo ngayon sa question and answer portion. I can read from the chat box. May mga questions tayo. What is the importance of estate planning in today's world? Especially that there is a pandemic. Alam niyo, all the more. Sabi po ni Ben Franklin that there's only two certain things in life. And these are death and taxes. And estate planning involves both, so that we can be sure that in case the two happens, our loved ones are well provided for. Estate planning helps you prepare for the inevitable, and so that those you leave behind ay hindi naman masyado mahirapan when that time comes. Bukod sa pagluluksa sa inyo, hindi na siya mamumroblema pa sa iba pang mga bagay, lalo na their needs. Now, there's another question. Can a person with power of attorney change a will? No. A will is personal, and delegating this authority to change a will is highly questionable. Siguro, makakaano later on, but it's not advisable. You will probably have a hard time proving this in court. When a person dies, does his or her spouse get 50% and the other 50% will go to his or her children? So, depende po yan. Again, kung intestate succession, wala tayong last will and testament, automatic 50% is really the conjugal share of the spouse unless may prenuptial agreement kayo na separation of property or conjugal partnership of gains. But the default provision in the Philippines is yung absolute community of property. Ever since the family code in 1987, ang ano po dyan, kapag kinasal tayo, what's yours is mine, what's mine is yours. So when somebody dies, na one of the spouses die, yung half is deemed to be the conjugal share, and then the other half naman, which will comprise our estate, yun ang hahatiin among the wife and the children. So kung may illegitimate children, 1/2 of the share of one child, and then yung spouse, yun yung share niya, same as a legitimate child. So hati-hati po sila doon. Is there a way to keep a special needs relative eligible for government benefits? So usually dito sa Pilipinas, hindi masyado maganda ang unfortunately, ang social welfare system. Aside from the usual benefits while we are living, there are PhilHealth deductibles, PhilHealth benefits that we can claim, therapy, mga assessment, but yung mga lab tests hindi po kasama. Ayun. And then there's for persons with disabilities, meron siyang 20% discount and 12% VAT exemption. So yung mga ganong but in terms of inheritance, pwede siguro you can leave an amount for the care of your child. So if you leave a last will and testament, or baka naman your surviving heirs can agree na maybe habang buhay ka pa, mag-set aside ka na ng special fund, maybe a trust fund for the said special child. Yun. It's another question. In your advice, how much wealth should I leave my kids? Napakaswerte naman ng mga anak nito. Tanong na to. Sabi po ni Warren Buffett, one of the richest men in the world, he said he will leave just enough so that they would not feel that they could do anything, but not so much so that they would feel like doing nothing. So that's good advice, di ba? Parang hindi siya mag-iiwan ng sobra-sobra na wala nang gagawin. Hindi rin naman siya mag-iiwan na halos parang kulang na wala nang magagawa, hindi na nila maabot yung mga dreams nila, di ba? So I think that's a good rule of thumb. Siguro isa rin, the right question is how much do you need to live? Assuming that you live a long life, diba? 65 ka ngayon, you're retired already, but what if you live to 80, 90, 100 years old? So that means about 30, 25, 30, 40 more years. So siguro wag lang rin lahat masyado because you might not leave anything for yourself. There's this Indian parable of a rich man. He gave all his wealth to his 5 sons, and after noon, medyo hindi na siya inalagaan ng mga anak niya. So, malungkot ano. So mag-iwan tayo for ourselves as well because you deserve it. You work for it, diba? Also, siguro depending on their needs or their situation in life. Maganda tong tanong na to kasi another anecdote comes to mind where tinanong yung nanay, sinong pinakamahal mo sa mga anak mo? Sabi niya, kung sino may kailangan at that time, sinong may sakit, sinong malungkot, sinong nasaktan. So, ganda, no? Very beautiful. So, usually, pwede naman, we can give more to those na medyo nakikita natin disadvantaged. Total, yung iba naman, strong sila or they have a good financial base, then maybe you can help those naman na hindi masyadong well-off or hindi masyadong as comfortable as the others in life. Sarap ng mga ganitong tanong, no? So, sana meron tayong ganitong legacy, no, for our children and our children's children so that they will be so blessed. Meron ako na-meet, nakakatuwa, grabe. Wonderful, elderly Christian family. They're into telecoms, telco, cable, real estate, daming ventures, and the 3rd generation na sila. And it's such a blessing to know na their children, one of their children is a missionary in Africa. Tapos isa naman nag-Bible school. So parang nakakatuwa, no? Parang very yung thrust ng family nila. It's not just to build wealth but also to help, to give back. Meron silang school na tinayo for children as well in the province, Christian school. So another question, in your personal opinion, when is the right time to start thinking about estate planning? That's a good question. It's actually basically about our legacy. So if your conjugal share, again, di ba, napag-usapan natin kanina, is more than 5 million or your conjugal share of the house is more than 10 million at sobra-sobra pa dun, then maybe it's a good idea to do estate planning. Pero kung yung bahay mo naman hindi nag-exceed ng 20 million or wala ka naman special circumstances sa buhay, hindi naman masyado magulo, maybe no need. But if you are in a complicated situation where there might be confusion or tension regarding the distribution of the assets, halimbawa may ex ka, may assets kayo, may children from a prior marriage or prior to marriage, meron kang anak, or if you are planning on giving to charity or to a school or to a church, then it would be good, of course, to do estate planning. May another additional question. Eligible for inheritance po ba ang illegitimate child kung originally dala niya yung surname ng dad na may panamana pero pinapalitan ng nanay to her surname? Well, under the law, under the family code and the civil code, eligible ang illegitimate children with half of the share of a legitimate child. Yun lang, if the child is denied na anak, then you have to present proof of affiliation. Ibig sabihin, talaga nga bang anak? So, usually mga letters, pictures, then last resort, DNA test ang pwedeng gawin. The problem is, kung namatay na yung isa, yun, it might be hard unless meron siyang other samples ng and DNA testing here, while it is already possible, still costs quite substantially. Tapos dalawa lang yata, tatlong institutions, sa NBI, sa UP, and I think sa St. Luke's They cost about 100,000. So meron pang question, yung lolo ko po hindi nakagawa ng last will and testament bago mamatay. Bago po siya namatay, may sakit na siya and medyo di na nakakilala. Yung kapatid niya po, illegally, without our consent, pinapirma yung lolo ko na ilipat yung titles ng lupa sa kanya. Paano po namin lalaban sa korto? Ano po advice niyo for next steps? Oh, good question. Actually, si lolo, kung meron siyang descendants, then the will can be invalidated up to at least half of yung pinapamigay niya. Yun lang yung ari-arian niya. Sabihin ng legitimate heirs ng descendants, na-deprive kami. So, hindi pwede yan. So, it has to be voided. But, again, if it can be proved that the will was made with fraud or may force, may panloloko, yun. Subject to evidence. Kung napatunayan yun, then may invalidate yung will dahil mawawala doon yung kusang loob at malayang pamimigay ng mga assets that is subject of the will. So it's a very, this is a very interesting topic. Usually, nagiging interesting to kapag kami pinag-uusapan naman na. Kung wala, hindi siya interesting. And so, yun, mukhang wala na po. By the way, we lost a very wonderful man of the law, a scholar, one of the experts, si Ruben Balane, my professor in succession, passed away last week, and my condolences to the family. He was a wonderful professor. We really learned a lot from him. Ayun. So, yun, throughout the pandemic, it's good to think about these things. Kung tayo ay merong iiwan sa mga mahal natin sa buhay, it's good to have estate planning. And kung hindi naman masyado okay ang buhay natin ngayon, sabi nga ni John Lennon, everything will be all right in the end. And if it's not all right, it's not the end. So yun lang po. And again, thank you mga OSHmates and mga ka-TGFI for the privilege of speaking before you this afternoon.